And now let's check out some of the top trending stories from the courtrooms.
We begin with the report that the Supreme Court has fixed July 6 to deliver judgment in the appeal filed by the Senate President, Dr. Bukola Saraki, challenging the ruling of the Court of Appeal, which asked the Code of Conduct Tribunal to try him on 3 of the 18 counts brought against him by the Economic and Financial Crimes Commission, EFCC. The Supreme Court fixed a date after hearing the appeal and cross-appeal filed by the Senate President and the EFCC over the allegations of false asset declaration. Senator Saraki is contending that there is no prima facie case against him, and as such, the Apex Court should uphold his no-case submission, which was upheld by the CCT. The CCT had in 2017 quashed an 18-count charge of false asset declaration and money laundering against Saraki by the EFCC for lack of merit. The tribunal agreed with the Senate President that he had no case to answer. On January 14, 2018, the Appellate Court agreed in part with the CCT but held that he had a case to answer in counts 4, 5 and 6, which had to do with his purchase of properties in the Ikoyi area of Lagos. Still at the Supreme Court, a chieftain of the People's Democratic Party, Friday Nwosu, today lost the bid to disqualify Governor Okezie Ikpeazu of Abia State. In a lead judgment delivered by Justice Sidi Baje, the Apex Court upheld the verdict of the Court of Appeal, which dismissed an appeal challenging Governor Ikpeazu's qualification. Nwosu, who contested a December 8, 2014 PDP governorship primary, had filed a suit accusing the governor of submitting false information and fake tax documents to the Independent National Electoral Commission. He had also asked the court to disqualify Ikpeazu and declare him the governor of Abia State. And in Lagos, a federal high court has ordered the EFCC to produce its last witness or close its case against the former governor of Oyo State, Rashidi Ladoja. Former Governor Ladoja and one of his aides, Wahid Akombi, are facing an 8-count charge of laundering 4.7 billion naira and unlawful conversion of funds belonging to the Oyo State government. Justice Mohammed Idris rejected a request by the EFCC for a 3-week adjournment to enable it to produce the witness, who is said to be the officer who investigated the case 10 years ago. The judge held that he could not adjourn the case beyond 7 days as allowed by the substantive law, and that's the Administration of Criminal Justice Act. The court subsequently fixed April the 20th for the EFCC to produce the witness in court or close its case. Another federal high court in Lagos has ordered a trial within trial to determine the voluntariness of certain statements purportedly made by a former minister of the Federal Capital Territory, Jumoke Akinjide, and 2 others charged with a 650 million naira fraud. Justice Malam Hassan gave the order for the trial within trial after the defense team contended that the statements were obtained under duress, threat and inducement by the EFCC. An investigative officer with the commission, Usman Zakari, last Monday told the court that the former minister, in statements made by her, detailed how the money was disbursed without the use of a financial institution. The witness also told the court that after the second defendant was arrested, he also confirmed his details in the documents showing how he assigned for the money disbursed to him. A move by the EFCC to tender the statements was resisted by the lawyers for the defendant, who submitted that the statements were made under duress and inducement. They then asked the court to order a trial within trial to determine how the statements were extracted. Despite the objections of the EFCC, Justice Hassan, in a short ruling, agreed with the defendant and ordered for the trial within trial, which has been adjourned to April the 23rd. And we round up with the report that another federal high court in Lagos has ordered a senior advocate of Nigeria, Dele Belgore, and a former minister of planning, Professor Abubakar Sulaiman, to open their defense in a 450 million naira money laundering suit slammed on them by the EFCC. Justice Rewan Aikar, who dismissed the no-case submissions filed by the 2 defendants, held that after a careful study of the prosecution's case, he had formed an opinion that the defendants had certain explanations to make. After the ruling, the court also directed the EFCC to file a formal response to the defendant's application requesting certain statements made by the senior advocate which were vital to his defense. Further proceedings have been fixed for April the 30th.
And that's the program for today. Many thanks for watching. Please feel free to send in your comments via any of our social media handles. You can also watch this episode of the program or past ones on our YouTube channel. I'm Shola Sheyeli. Thank you for watching.